Okay, thank you. All right, so Ms. Gianetti, I remember clearly the lines of inquiry that you initiated. So I disagree with you in the strongest way possible. You've made your record. Your motion's denied.
Thank you, Your Honor.
Okay, so let's bring in the jurors, please.
Did this judge just make a biased decision? Let's talk about it. Hello, everyone. Welcome. Let's first generally talk about a judge's decisions. And I will often use the term judge or court interchangeably because the judge, once they put on that black robe, they represent justice. The court's decisions will not satisfy every litigant every time, meaning one side in a trial or hearing is not always going to be happy with how the judge has administered the law. The issue is not all judges administer the law in the same way. They each interpret the law with their own interpretation, and this is where bias can produce unfair results in their rulings, as judges have a lot of discretion. And when a judge administers the law, they have a duty to ensure the process is fair. And we use this phrase, the judge is the gatekeeper, for this reason. So when I look to determine if there is bias, which means is one side being favored more than the other, or is it the way the law has been interpreted, or is it because the judge has discretion? And we need to know all this before we even think about appealing a judge's decision. So we're going to look at a great example that took place in the accused Karen Read's trial. This is going to get emotional. So let me give you a bit of a backdrop. The parties had agreed that they would not elicit information regarding harassment that the witnesses have received. The judge made a decision that the harassment testimony would not be presented to the jury by the defense or the prosecutor. But if the door was opened, the judge would not prevent a witness from giving testimony about their harassment. Well, you can guess what happened. Yep, a witness quite cleverly managed to answer a question by the prosecutor in response on redirect to a question that the defense had asked, which we'll discuss in a bit. But first, I think it's important that you see the witness and how she cleverly responded to the prosecutor's question, which, by the way, she had already answered before. So now her testimony has slightly changed. Let's have a listen.
What, if anything else, has either your family or Colin Albert and his family undergone over the course of the pendency of this case? Objection.
No, the door's been opened. I'm allowing it.
Well, basically harassment.
Harassment by who?
Bloggers, people online.
And what, if anything, in relation to Colin Albert being in the house has occurred as far as the harassment that you're talking about?
Can you rephrase?
With reference to what you were talking about as far as the relevancy of Colin Albert being in the house at that time, what, if any, harassment was there in relation to that and in relation to Colin?
Well,
No, go ahead. She can answer.
Colin wasn't at the house, so he's being harassed he was not at the house when John was there, so I drove him home. So people are harassing him saying he was at the house when it's not true.
When you speak about harassment, what specifically type of harassment are we
Constant phone calls, emails, awful messages.
Objection.
I'll allow it. Focus on this witness, not Colin Albert at this point.
As far as you and your family, what, if any, type of harassment have you received?
People showing up at our house, people emailing my school, just like a lot of harassment. Can I have a moment, please?
Sure.
Okay, I'm sorry. I have some, thank you.
And how long a period of time has that persisted for?
Very long time.
Thank you. I have no further.
Okay. All right, Ms. McCabe, you're all set.
And in this case, the witness did give an answer to why she hadn't handed over the information sooner to law enforcement. And she said it was because Colin Albert's time of leaving the property hadn't been an issue before. When she had heard that it was an issue and that it was being alleged that he left when John O'Keefe arrived, She remembered that she had a text exchange with him because he had asked her to pick him up. So she could indicate, what time she arrived to collect him. And that would prove that he couldn't be there at the time when John O'Keefe arrived. So let's watch that clip of her providing the evidence that she collected Colin Albert. See if you notice anything odd.
Now, what's up on the screen, Mr. Cave, is that what you have before you as the exhibit?
Yes.
And looking at, there's sort of one side has text and one side has blue bubble, is that correct?
Yes.
And if you know who is communicating with who as far as the sort of plain text outside of the bubble?
Colin and I? Is that what you're asking? Sorry.
What I'm asking is, who's the blue bubble?
Oh, sorry. I'm the blue bubble and he is the gray, whitish bubble.
And from sort of top of what's depicted on the screen, you read the text that you received and the time that you received.
Yes, 11:54, and then I responded at 11:55.
And what did Colin say at 11:54?
You can get me now if easier.
And what did you respond?
Okay, I am driving people home now.
And what did Colin respond to that, and what time did he respond?
He responded, word, get me after.
And it's going to scroll down. And following the getting after, what if any response did you provide?
KK, okay, and here,
And here that you texted, what time does that read on the screenshot?
12:10 a.m.
And what if anything did Colin respond to the your text?
He responded at the same time saying, okay.
So the defense quite rightly questioned why these screenshots of text exchange didn't look quite right. Can you notice how the date of 12 a.m. did not change over to the next date? So that is a bit odd. And she had no response to this. She had gotten a new phone. So I think now she's like the fourth person to exchange her phone and did not keep the old one. So the internal data did not transfer with the screenshot. So there's no way of validating when the screenshot was taken. So let me just zoom in so you can see it a bit better. The defense asked if she had changed the internal time because they had evidence from another app that she used called 360 that showed her locations did not match up with this text messaging. So she had already testified that she took the screenshot after being questioned by the state some 9 months after the incident at the Albert's house when John O'Keefe's body was found. How could the date have not changed over? As you can see, the date that you see on the screen is the 20th of February 2022. However, prior to that, I would expect to see the 29th of January 2022 being displayed between the two blue bubbles when she responds KK and here, as this is when the time changed from 12 o'clock. So to me, this evidence looks contrived. What's even more interesting about this is the prosecutor, in my view, deflected the dodgy evidence by eliciting another reason for the delay instead of addressing the issue of trying to understand the complications of technology. If you saw the movie The $1 Billion Code, this case was in the 1990s where a Berlin artist and hacker invented a new way of seeing the world. Years later, they reunited to sue Google for patent infringement on it, the app we may all recognize as Google Earth. The lawsuit was lost, some speculate because of the complicated evidence on code writing and technology that was lost on the jury. So that is why I think it was clever that she responded and transitioned to an emotional reason for the delay in providing these text messages. So what do you think? Should the judge allow this kind of testimony in? It has to do with harassment, and we're going to hear the defense argue that the testimony should not be allowed in, and we're going to hear the prosecutor argue that it should be allowed in. So let's listen to that, and then we'll listen to the judge's decision, and then I'll give you my opinion.
We don't need to be seen at sidebar, Your Honor, but I do need to be seen about an issue from yesterday.
You'd like to be heard?
Well, yes, I would.
Okay, I'll hear you. What is it about?
Your Honor, we are not only renewing our objection to the alleged harassment evidence that came in yesterday, but we're specifically moving to strike that testimony and specifically asking the court, before we get started today, to instruct the jury that they are to disregard that evidence. And I wanted to point out to the court that it is our view we didn't even come close to opening the door to that evidence. I had just asked the witness if she had turned over those text messages to the state police when she spoke to them on August 25th of 2023. I've asked every witness when was the first time that they spoke to the state police. That was the first time Ally McCabe spoke to the state police. None of that conversation had anything to do with harassment whatsoever. It was strictly related to the death of John O'Keefe and the investigation of John O'Keefe. I stayed completely clear of any discussion of harassment whatsoever. I only focused on the federal grand jury and the approach by the state police on August 25. I opened no door. I didn't even approach the door. And yet that evidence came in. It led to a moment where, that Mr. Lally, I believe, has been waiting for, which is for a witness to break down on the stand and feel sorry for themselves to gain sympathy before this jury. It was prejudicial to our client. It's prejudicial to our defense. It is error, and we're asking the court to correct it.
All right, what do you say, Commonwealth?
Your Honor, counsel absolutely opened the door as far as the questioning was concerned. It was not just the characterization of the questioning is just simply inaccurate. As far as the questions that were posed to the witness, it was more geared towards why, implying that the witness only provided this after testifying at the other proceeding or being questioned about it in that environment, and that's the only reason that she had these messages, and why hadn't she turned these messages over earlier? And that is in direct response to the harassment that that witness and her entire family, as well as Mr. Albert, had sustained as a result of actions by several different parties, including counsel. So for those reasons, it was proper. There was nothing, I don't think it was more than 5 minutes of testimony concerning it, and it was because counsel opened the door to it.
Okay, thank you. All right, so Ms. Giannetti, I remember clearly the lines of inquiry that you initiated. So I disagree with you in the strongest way possible. You've made your record. Your motion's denied.
Thank you, Your Honor.
Okay, so let's bring in the jurors, please.
Wow, the judge's words saying she strongly disagreed with the defense clearly indicates she sided with the Commonwealth. I think the court viewed the harassment testimony was offered as the reason the witness did not provide information sooner. The problem is I'm left guessing, and since I'm not on X, we'll have to do our twittering here and now. So the judge, by saying she remembered the line of questioning the defense had given and she strongly disagreed, she's not detailing her thought process, and this gives the appearance of being biased. But remember, bias is being favorable to one side over the other, and her decision is discretionary because she had already decided that if the door was opened, she would allow the harassment testimony in. However, that decision in itself was open for interpretation if you think about it. In the first place, because asking any why question could technically, according to the Commonwealth, be opening the door. And by the judge, she seems to agree with the Commonwealth. I think that's where I think she's a bit biased. So, was the judge biased in your opinion? Let me know your thoughts. Did the defense already get the answer from the witness as to why she had not given the information over to the state until she found out that Colin Albert was being accused of being at the party when John O'Keefe arrived? And she only gave that information over when she realized that he was being accused of being at the party at the same time as John O'Keefe, and since she had picked him up, and she came up with some evidence that we looked at and I think is a bit dodgy. So was it a bit sneaky that the Commonwealth or the prosecutor asked her, is there any other reason why you didn't hand over this information to the state? He should have known that would elicit the answer that she gave, that she was being harassed. And I thought the judge had already said that the parties were not to elicit the information, but if it came out naturally, then she would allow it in. So, yeah, that's why I think she was being biased. I do not condone any form of harassment, but we do see in these high-profile cases where the public does take a strong stance. We saw it in the Gabby Petito case where Brian Laundrie's parents had lots of people parked outside their house and harassing their family. So, this is something that isn't very nice, and we should really let the legal process take its course. So let me know your thoughts. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.